What up? Sorry about the black screen. And sorry I'm a little schlubby today. I've been dealing with some stomach bugs all day. Just kind of woke up on and off. Slept for about like 12 hours. But yeah, I got some new court documents. I am going to be reading those off in a second. Let me start by opening them up. Downloads. So first, this is one from yesterday. So let's zoom in here. This one's pretty quick, so I'll just kind of go over it. But yeah, how's everybody doing? No, there's some really good documents in here. We got a new judge. We have some dates for huge things. And then we have uh, some code of conduct stuff. But yeah, so we got some pretty big documents here. Fruit snacks, hell yeah, dude. How you been, dude? Spooky. Let us, but yeah, let's get right into it. So the first one is the minutes. So this is more minute order reassigning case. So the magistrate judge is not going to be the judge that's moving forward with the case. So the old judge is gone. Um, there's a new judge now. So this action has been assigned to the Honorable Tana Lynn, United States District Judge. All future documents filed in this case must bear the case number, and then it has the new case number, um, and bear the judge's name in the upper right-hand corner of the document. Hold on one second. Excuse me. Oh, hey, bird. I didn't see you there. Hey, kitty. She is very interested in what I'm doing. So yeah, we have a new judge, Tana Lynn, the honorable Tana Lynn. I read up a little bit on her the other day. Um, she's decent. I'm gonna make a new video probably tomorrow on all of these documents and kind of go over who Tana Lynn is. But she's not bad. I have a 14-page script with evidence that I need to read tonight. So I kind of want to get through these documents live first, and then I'm going to make a video about that. About basically how much and how often Nexon has been lying, and just go over two documents. I have 14 pages of evidence from two documents, just the DMCA and the initial complaint. There's 14 pages of script and evidence from two documents of how Nexon's been lying and kind of just making shit up. A lot of it can be simple mistakes, but a lot of it is more questionable. Um, so I want to go over that later today. I'm going to do my video. That's what that one's going to drop tonight. I'm going to record it and edit it directly after this live stream. But yeah, so Tana Lynn, we have a new judge, which is pretty exciting. A little bit about her. She was a public defender for years and years and years and years, which is like the worst job ever. Um, it's literally the worst job. Oh, if you want to know what the video is going to say, my Patreon has the script already up. It's been up since last night, um, or basically this morning at like 3 o'clock in the morning. But my Patreon has a script up for like $1. So if you wanna go read it, you can. Um, there's a lot of stuff in there, and that video, the evidence video, is probably gonna be two-parter because I want to go through what they've submitted in Korea, which is more stuff. What they've submitted in Korea, and uh, there's more documents here that they've lied on. So there's a lot of stuff. Nexon is just kind of speaking out their ass, but yeah, I don't want to kind of give the video away. So But yeah, they've been doing a lot of suspicious stuff. A lot of suspicious stuff. Did One Pig's vid? I haven't seen One Pig's video. Um, but yeah, new judge. This one's not super exciting. Let's go over the initial disclosures. So this one's huge. The initial disclosures is the big one. So what the initial disclosures is basically them giving all of the dates for when they're going to do everything. There's nothing in here about the cases being dismissed, at least to the best of my knowledge. I haven't read them in full, but um, we have the initial disclosures and everything right here. So this sets out the date. So the early case conference, basically the deadline for the early case conference is 7/26/23. So it's about a week after when I thought it was. So they gave them until about early August, but the judge said no, we want it done in July. So end of July 7/26/23 is the deadline for the FCRP, which is the what does that stand for? It's like the Federal Rules of Civil Procedure, I think. Let me make sure. I want to verify that. Yeah, Federal Rules of Civil Procedure. Is the FCRP. So if you look at the document, it's FCRP 26F. So that means it's FCRP paragraph 26, section F. So that's how you read legal code. Federal Rules of Civil Procedure, paragraph 26, section F, or section 26, paragraph F. Sorry. Um, and then this would be the initial disclosure pursuant to FCRP 26F or 26A1, right? So section 26, paragraph A, um, section 1. So the initial disclosures are going to be on 8/9/23, and then the combined joint status report and discovery. So discovery is going to be 8/23/23. So this is all pretty much according to the same timeline. If you look up, I have another video, and I'll look it up here. There's a timeline that goes over this pretty well about why this stuff is scheduled the way it is. They have a very strict timeline that all this stuff goes through. But we're gonna have the early case conference is going to be on or before 7/26/2023, so next month, around the same time as we're going to figure out the 21st is when we hear about the initial injunction in Korea. So like basically within the same 7-day period. And then the initial disclosures for discovery are going to be on 8/9/23. And then they're going to have a combined joint status report and discovery plan as required by FRCP 26F and local civil rule, so LCR 26F. And that is going to happen on 8/23/2023. And what that means is, so early case conference goes on the 26th. They're going to go in. They're probably going to talk about the dismissal. They're going to talk about all kinds of other motions. They're going to do basically every single pretrial hearing is going to happen on, at least to the best of my knowledge. I haven't talked to lawyers about this yet. I'm reading this live, so I've scanned it, but I haven't read it yet, like read it in full yet. So, but to the best of my knowledge, the FRCP conference is basically the early case conference where they go and have a bunch of pretrial hearings, and they go over all of the motions and all of the pretrial hearings for like dismissals and what's allowed in court, what the dates are specifically, what the rules and stipulation of the court, like how they're going to proceed moving forward. Right? Here's what is allowed. Here's what's not allowed. If they have, if say if Iron Mace wants to have all of the evidence they've lied that Nexon has lied on thrown out, they'll have all that thrown out. If the case gets dismissed, it'll probably happen on this date. In some situations, it can happen before, but it'll probably happen so on or before 7/26/2023, and then they do a lot of stuff that day, and then they start building their case from that point. It goes into discovery. The discovery period's pretty long. So then they start having the initial disclosures and basically talking to each other and saying, "Here's what I have. Here's what I have," and then that's they have to have all of this stuff, the initial discovery done by 8/9/23, and then they hold a joint status report and discovery on 8/20/20 or 8/23, yeah, 23, and they show everybody what they get together. They say, "Here's what we have. Here's what we have." They talk about a settlement again. They go over basically a big ass stack of evidence with the judge, and the judge is going to go, "This is going to stay. This is going to stay. This is going to leave. This is going to leave," and they start going over and tossing that in, and then they set another date for the end of the discovery phase. So you have another X amount of days to file all of the paperwork you want to file and get all the motions you want to have forward and get all of your evidence in place. Because then by the end of the discovery phase, they should have all of their evidence approved by the judge. And this is where they go over, here's where they disclose their evidence, here's where the evidence is going to get approved or denied, right? And they're both going to be able to see each other's evidence, right? So they're going to start filing a bunch of paperwork here soon. And then, as it says, any request for an extension of the deadlines above must comply with the procedures set forth in this court standing order for all civil cases. See this link. Yeah, I'll allow that. I'll download that right now. Okay. So there's that. Let me go back to this. So I don't just download this. We'll look at that too. Plaintiffs and any defendants who have appeared shall meet and confer before contacting the court to request an extension and include a certification as to this requirement with any opposed motion. Wait, what? If this case involves claims that are exempt from the requirements of federal rules of civil procedure, there it is right there. Please notify Kada Peter, courtroom deputy, at their email address so the court can modify the case and schedule order as necessary. So this goes into procedural information, and then so this is how you do everything. I'll read through it, but I just kind of want to see how they have this outlined. And then plaintiff's responsibility, early settlement considerations and notifications, and then it's signed. Okay, cool. So it's not super long. But yeah, let me get into the procedural information. I'm going to check my second monitor broke. I have like a little portable monitor and it broke. But yeah, I haven't watched One Peg's video. And then yeah, if you want to know. No. So early access, not no. So the case might be stopped. We're gonna know about an injunction. We're gonna know about an injunction no later than 7/29/23. So that's the early case conference. That's when the injunction motions for injunction will be looked at, and we'll know for sure when it like if the case could get dismissed that day, there could be an injunction that day. All kinds of stuff can happen during the early case conference. So by the end of that day, we're going to know exactly where we are. Let me look. Hey, there's 19 people here. Heck yeah. So I'm going to kind of type this in the chat. So $729.23 what was it? It was discovery was, or the initial discovery was 8/9 through 8/23. Yeah. Oh, 26. Yeah, yeah, yeah. Sorry. Let me see if I can edit this. Removed. Retracted. Thanks. Good catch. Discovery and early case conference. Discovery starts and early case conference start at 7:26:23, but it can be thrown out then. And then discovery meeting is 8:23:23. Cool. So yeah, I mean that's when we'll know. So the early case conference is basically what's going to set the injunctions in place, if any. It's going to probably notify us if the case has been dismissed. Um, so the judge is going to spend the next month almost, so the next like 28 days, looking over this case and then deciding if the injunction should be in place, deciding if uh, the dismissal should move forward, and all of that. And then we should know on or before the 26th of what happened. So I hope that makes sense. Heck yeah. Thanks, thanks, Ben. I appreciate it. Thanks for watching. Um, yeah, thanks for everybody who's popping in. I just got YouTube partner, so I have like all kinds of cool stuff that you guys got for me, um, which is pretty sweet. 22 people, nice, dude. Yeah, this is huge for me. I mean, 22 people may not seem like a lot, but for me, this is huge, especially on like YouTube streaming. I don't really like Twitch, but YouTube's pretty chill. Um, and I'm just super glad that you guys are in here chatting and talking to me, um, and watching and reading these documents with me. But yeah, let's get back into this. So this is procedural information. This is kind of stuffy and boring, but it's important. So all counsel and parties are encouraged to advise the court of their pronouns and honorifics such as Mr., Mrs., MX, by, for example, noting them in signature lines or advising the courtroom deputy before a hearing begins, either via email or in person. The court has a strong commitment to fostering the development of new and diverse lawyers in the legal community. Consequently, the court strongly encourages litigants to provide opportunities for less experienced lawyers or lawyers whose identities or background further the diversity of the legal profession to conduct hearings before the court, particularly where contributed significantly to the underlying motion or prepared witness. While typically only one lawyer may argue on behalf of a party at a hearing, the court may allow multiple attorneys to argue on behalf of a client to achieve this end. So what this means is like, usually there's only one lawyer that's arguing at a hearing, so they're like the main lawyer. But if you have a less experienced lawyer or like who like is part of a minority or um, specific group of people, they may give them like a chance to argue in the hearing so that they can get experience, right? Especially if they're learning. So this is kind of for training new lawyers, especially minority lawyers. Um, and this happens in Washington. A lot of places have adopted this. Um, but the counsel should advise court prior to hearing if they intend to have multiple lawyers argue a case pursuant to the court's commitment to diversity. Um, so, like, if you have a more diverse staff of lawyers, you could actually benefit by having multiple lawyers act as like the main speaking lawyer. Of course, ultimate decision of who speaks on behalf of the client is for the client and not the court, right? So the client has the final say of who actually speaks for them. Um, All counsel and pro se parties shall review the local rules, electronic filings, for criminal and civil cases, court forms, instruction sheets, and general orders, which can be found on court's website. In addition, all counsel pro se parties shall review Judge Lynn's chamber's procedures. So she's going to have a special way that she does procedures, and they're found here. I will look at this. Patent cases. Okay. What's her agenda for the pretrial conference? I will download this, because this is going to be important. So I have that. So I'll read that afterwards. So I have her agenda up and how she does her early case conference. Do you guys want to see that now, or do you guys want me to hold off? Ruling on the amongst us, the ruling on the dismissal will probably happen on or before the early case conference, which is, we just got the schedule for that. That's 7/26/23. So on or before then, we'll know about the dismissal. Yeah, I highly doubt. So early at my best case scenario for early access is sometime anywhere between July 21st through now, like July, what would make sense? So their initial injunction hearing in Korea is the 19th, and then 26th for United States. So I would say anywhere from the 20th to the 27th, maybe the 28th is probably like my best guess for EA. Is like we'll at least have word of when they'll do EA for that July 26th through, or July 20th through 27th is my estimate. 3% chance. Yeah, but no ruling on the dismissal yet. What if they give IM their injunction against Nexon? Does that mean that they revoke their English lawsuit once? So, no. What it means is, so if should both cases move forward and Nexon get the injunction in Korea, it means that, oh, whoa, thank you. Thanks, Mike. I really appreciate that. That's huge for me. That's my first ever. Thanks, Mike, for my first ever donate. I don't even know what they're called here. My first ever super comment. But yeah, thank you so much. That's hugely appreciated. Putting that towards the new mic. So if the initial injunction goes against Nexon in Korea, I don't think they will be able to DMCA in the United States. However, it's going to get tricky. I'm going to have to talk to a lawyer about this, to be perfectly honest. But it's going to be kind of tricky because if there's still an ongoing lawsuit in the United States, even if they have an injunction against against Nexon in Korea, they might be able to still get away with filing an injunction in the United, or filing a DMCA in the United States. So, but I'm not sure. I'm not sure how that works because there's still an ongoing case to decide all of that. Now, I think the injunction in the Korea would put an end to it because that would be considering messing up their business, and both corporations are based in Korea. So I think regardless of what's happening in the United States, if Iron Mace wins in Korea on the injunction battle, I think Nexon can't really do shit about it because United States and Korea both have to follow each other's laws, IP laws, and that would be involved. So But I'm like 90% sure that it would stop all DMCA's. But there is still a small chance that if the case in the United States moves forward, they can still DMCA in the United States. It's a little muddy, but I'm gonna have to talk to a lawyer again specifically about that exact scenario. Like basically, what if it switched? Like uh, Iron Mace wins injunction in Korea, but Nexon wins injunction in the United States. What happens if those two are at odds with each other? I'm not entirely sure. Yum chicken noodle. Heck yeah. But yeah, thanks again, Mike. That's awesome. That's huge. That gets me a quarter of the way to a new mic. I think the mic's on sale right now for $40. I'm gonna get a blue snowball. But I also want an arm, like a mic, like a boom arm that comes in, so I have it like right in front of my face. Um, and I think that's like another $20. So that setup's gonna be like 60. The new monitor I want isn't really. It's like a 144 hertz cheap, smaller gaming monitor that I'm gonna put next to my big 4K. Um, and then the camera, because right now I'm using my phone. I don't know how it works. I'm using the front camera on my phone. But my setup is super basic. This headset's like a $25 gaming headset from Target. Like it's super. It's I didn't plan to start doing this. Um, I just kind of started doing it. But yeah, thanks, Mike. Um, but let's get back to the case. So they have to follow all local rules for electronic filings and procedure for criminal cases, court forms, instruction sheets, and general orders, which can be found in court's website there. They have to follow lead chambers procedures, which can be found here. I already looked through some of them. Um, and then counsel and pro se parties are expected to abide by the requirements set forth in the local rules and general orders, as well as Judge Lynn Chambers procedures. Failure to do so may result in the imposition of sanctions. As noted above, all counsel and any pro se parties are directed to confer and provide the court with combined joint status reports, discovery plan by August 23, 23. So that means that they have to have, yeah, like she said, everything for discovery has to be brought forth by August 2023. So that's their status report. They have to have all of their status report for discovery in by August 23rd. This conference shall be direct and personal communication, whether that be an in-person or virtual face-to-face meeting or a telephonic conference. So Washington court allows basically Zoom calls, in-person, or telephone, or some kind of mixture, I believe. And the report will be used to schedule for the prompt resolution of the case. It must contain the following information by corresponding paragraph numbers. So this is what is important about this date, August 23rd, 2023. This is what Judge Lynn is demanding. A statement of the nature and complexity of the case. So she wants a detailed statement with all of the evidence set forward, basically like an entire big document that states exactly what this case is about with evidence. And then, so by August 23rd, 2023, so this is like after disclosure or discovery has started, so they're gathering evidence, and she wants like the statement with evidence in place by August 23rd. The parties have the right to consent to assignment of this case to a full-time United States magistrate judge. So they can put a motion forward to, if they, before August 23rd, they could one of the parties, either one, defendant or plaintiff, can put forward a motion to change the judge again. But that has to be done. She set the date for that to August 23rd, 23. So they have to request a new judge by August 23rd, and they have to have their full statement in with documentation in by August 23rd, which is huge. Super, super, super important to the case. This is kind of what I've been waiting for, to get this gives me a much more accurate timeline, and then I can give I'm gonna do a new court timeline video. Probably like not this video or the next video. I'm gonna like the video after that. I'm gonna do a quick court timeline video. So probably like 3 or 4 days from now. Because from these dates, I can extrapolate like a on or before timeline for like the entirety of the case except for trial, right? So, which is huge. We could get like an almost like a pretty exact timeline for what this how this court case is going to go. Oh, I don't really need 144 because it's going to be for chat and stuff like that. Um, what's up, Tadpole and Phantom? So far I've gone over. We've gotten some dates. I'll scroll back up for a second just to get everybody a refresher. But this is the most important stuff in this document. Everything else is just going to be rules and and stuff. But I do want to go over some of this. I might skip some stuff just because I don't want to sit here for 3 hours. But here's the important stuff from this. So we have a new judge. The new judge is the Honorable Lynn. And we have the early case conference 7/26/23. Initial disclosures is 8/9/23. So early case conference is all the pretrial hearings. Initial disclosure is their initial findings in discovery, and then they have a joint status report for discovery on 8/23/23. And from these dates, I can kind of calculate the rest of the dates for the trial, basically, at least an on or before date. So it'll give us like the final date that this can be by, right, for the rest of the trial. So I could get a pretty accurate deadline. We've went over the rules. So by August 23rd, the judge wants an entire statement for the case with documentation, and that's going to be August 23rd. And then if they want to request a new judge, they have to have it requested by August 23rd. That's the most important stuff from this document. And then we have the new judge, of course. And then the judge's specific rules as well. So the parties should indicate whether they agree that the Honorable Judge Michelle L. Peterson may conduct all proceedings in this case, including trials, which they already have a new judge. So this doesn't really matter. Including trial and the entry judgment. Responding to this question, parties should only respond yes or no. Individual parties' response should not be provided. A proposed deadline for joining additional parties. So there's going to set a deadline for if anybody else is going to join the case, any new lawyers or any defendants or plaintiffs or whoever, there's going to be a deadline set. I believe that's going to happen in the early case conference. And then class action noted only, which this isn't. And then it's going to go a discovery plan. So 5 is a discovery plan that states by corresponding paragraph letters A, B, etc. So this is their discovery plan. The parties' view and proposals on all items set forth in Federal Rules of Court Proceeding 26F 3, which includes the following topics: initial disclosures, subjects, timing, and potential phasing of discovery. So the timeline for discovery. This is all the stuff that's going to happen on 7/26/23. So the initial disclosures, subjects, timing, and potential phasing of discovery, any issues about discovery or electronically sorted information, privilege issues, so rules and privileges of the lawyers and the defendants and plaintiff, any changes they want to discovery, limitations imposed under the federal and local civil rules, the proposed limitations on discovery, the need for any discovery related orders. So that would be motion to dismiss evidence, to add evidence into discovery, basically anything that has to do with evidence or discovery in general is going to be, that's all those motions and related orders are going to happen then. And then have to be in by August 23rd. So you can submit them there. If you want to submit a motion or an order, you have to submit it either from anywhere between the early case conference on July 26th to August 23rd. That's their window to do all of this stuff. The parties views proposals and agreements by corresponding paragraph, letters A, B, C, etc. on all items set forth in local civil rules. So this is all federal stuff, and then here's the local rules. Local rules demand a prompt case resolution, so as early as possible. They're gonna. So the earliest, Washington goes by the earliest of two dates. So if it's like, say it's between July 26th and August 23rd, they're gonna pick July 26th. They always go for the most prompt case resolution, the earliest day between two dates, right? Alternative dispute resolution, so they always try to push for a settlement because they're swamped with cases, right? They want these cases gone. They want these cases out of here. They want all related cases. Usually, so what this means is that if there's any related cases, they'll try to wrap them all up into one. They discuss how they want to set a ruling for how discovery management is. So if there's any related cases, they're gonna wrap them all into one and then do one giant discovery for all of them. And then if there's any anticipated discovery sought, so that means you inform the court of stuff you plan on putting into discovery before you put it into the discovery. Phasing motions is basically timing. Preservation of discoverable information. So this is basically, I believe it pertains to multiple copies, and you have to have adequate preservation. And like basically this means like has to be kept secret, can't be disclosed to the public. If it's like secret or if it's public, it has to be made publicly available. And it can't be modified. And if it is modified, it has to go through these certain rulings, and they're gonna set all this stuff. All of this stuff is going to be set in the early case conference. So there's going to be, here's how we handle all of the information in discovery, and here's how we preserve it, meaning like make sure it doesn't get corrupted. So privilege issues, so any special rulings for the like local, because there's federal privileges and then local privileges. So there's going to be any, like if there's a special local ruling, say that pertains to like how Washington allows for multiple lawyers if it makes for a diverse team of lawyers, right? So that would be a privilege. That'd be a local privilege. So modal protocol for discovery, ESI. I'm not sure exactly what this means. And then alternative to the modal protocol. I'm gonna look this up real quick because I don't want to give any false information. I'm not sure what modal protocol is. Okay, so ESI Modal Protocol is a negotiated document that expressly states how the parties to litigation should produce electronically stored information. Okay, so this pertains to digital filing. So yeah, Modal Protocol of Discovery for ESI. So this is, they're going to set up the rules for digital filing and then alternative methods to ESI. So electronically filing documents. That's really it. The date which discovery will be completed. So they're going to set this date sometime between July 26th to August 23rd. Will be the end of discovery. They're going to set the date for it. Most likely, they're going to set this date on July 26th. Whether the case should be bifurcated, e.g., by trying the liability issues before damages issues. So if there's any other liabilities other than damages, they might counteract each other. So like, say Nexon wants both a percentage of the IP and a percentage of profits. Well, if they get the total IP, they can't have percentage of profit because they own all of the profit. Iron Mace would then not own the IP anymore. It would be Nexon's, right? So you can't have both. There's things that that just don't work together, right? Like, or say Nexon is granted a permanent injunction against Dark and Darker, and the game can never come out, right? If that's the case, they can be awarded damages, but they can't be rewarded percentage of sales because there will never be any more sales, right? So they have to basically pick, like, what do you want? So we'll know what the damages and liabilities are as of 7/26. Not like they won't be awarded, but what they're asking for and like what the official damages and liabilities are, according to this pretrial hearing, are going to be decided in July 26th. Whether pretrial statements, at least that's what, to the best of my knowledge. I'm not a lawyer. This is all just to the best of my knowledge. Um, then whether the pretrial statement and pretrial order called for by local civil rules, okay, that shall be dispensed in a whole, yeah, so whole or in part for part for economy. So I believe this is local civil rules. I'd have to look into this. I don't want to comment on this because this might be when they do the dismissal as well. Whether statements and pretrial orders called for by local and civil rules should be dispensed in whole or in part for economy. This might include the dismissal. I'm not sure. Whether the parties intend to utilize the individualized trial program set forth in local civil rule. I'm not familiar with Washington law specifically, so I don't know what that is. So any alternative dispute resolution set forth in local rule. So this is like, say they decide to handle this and set in like a third party settlement agreement. I don't think they can arbitrate this because it's over $500,000, but they might like agree to basically settle this outside of court. And they have to notify the judge, and at least talk about it on the 26th. I think they can choose to do a settlement before or after that as well, but they have to file a motion to settle and both the plaintiff has to file for a motion to dismiss based on settlement. If it happens after this. Any other suggestions for shortening and simplifying the case? So also dismissal would be wrapped up into this. The date the case will be ready for trial. So this is going to be, they're going to set the trial date like the latest it can happen, because they'll select a trial date, a hard timeline for the trial later on. But this is their like basically this is the on or before date. They're going to set that in July 26th. The court expects that most civil cases will be ready for trial within a year after filing the report. So that's the day of the complaint. So no longer than 12 months after filing the complaint, it has to be in trial according to Washington law. If the parties will be postponing the trial more than 14 months from the date of the filing of the report, parties shall include in this section of the report an explanation as to why the additional time is required, and that will probably be denied unless it's emergency. They've already declared whether it's going to be so they're going to decide whether it's going to be a jury or non-jury, but Nexon has already asked for a jury trial, so it will be awarded. But this will be made official on July 26th. The number of trial days required. The party should plan for 5 hours of testimony each day. That's basically what it says. The name, address, and telephone number of all trial counsel. So everybody that you want on your team has to be in by July 26th. Adding additional people will require a motion and can be denied by a judge if they want to try to add more people later. The dates on which trial counsel may have conflicts or other complications to be considered in setting a trial date. If on the due date of the report all defendants and respondents have not been served for counsel or plaintiffs, shall advise the court when services will be affected, why it is not made earlier, and shall be provided in a proposed schedule for the required FRCP 26F conference and FRCP 26A initial disclosure. I'm not sure what made them go with a new judge. Yeah, so Eric, I'm gonna be dropping the video. I'm gonna be dropping the evidence video tonight after I'm done reading all of this stuff. I am going to be doing the evidence video. I was gonna record it last night, but or like basically this morning. I was up until like 4 a.m. this morning, and I was reading. I was doing the script for it, and it just got to be 14 pages of evidence and script. So I was like, I'm not gonna record this tonight. I'll do it tomorrow. And then I was pretty sick earlier today. I had some stomach issues, so I don't want to go into detail, but yeah, I was grinding until 4 a.m. Didn't get to bed until almost 5 because I spilled a whole thing of cat food on the floor last night because of this little girl. Um, but yeah, it'll be done tonight. I'll have it done tonight and posted. I'm gonna record directly after this. Probably take a little break and then from the camera for like 20 minutes and then record. But yeah, I have no idea why you well. To be perfectly honest, that the magistrate judge and then the full-time judge on the case are usually two different people. Oh, it's good. It's good evidence for Iron Mace. It's 14 pages of evidence of how Nexon is just basically lying, or either is incompetent, straight up lying, or made huge mistakes because they've misfiled all kinds of stuff. So a good example is this: they make a claim that they spent months deliberating the choice on whether or not to have potions glowing in their game, and they made this in the complaint, and they made this in an official statement. However, the potion pack that they used in P3 and in Dark and Darker come with the glowing setting on. So like the potions they just straight up bought from the internet that come pre-made, all you do is you get a pick, you just pick your color. They come glowing. So that decision was basically made for them. They could have found a way to turn it off, but yeah, they come glowing. And then they said that it took them months to make a decision to for the correct color scheme and qualities of the light for the campfire and the torches, and they just used a post processing filter over the stock settings for the lights. I can tell because I have the same stuff in my game. So, and I put a picture of my game in there, which has the exact same lighting scheme as P3 does, because it's freaking stock, and I'm using the same torches and campfires. So, and same flame, like it's the same exact thing. And the post processing, all it does is you change the strength of the contrast, basically. But yeah, it's hilarious. The amount of evidence that is there of them just being either idiots or straight up lying is overwhelming. Nexon is fucking up this case pretty bad, at least in my opinion. What up, Nolan? Um, TLDR, new judge, and we finally got dates for the early case conference, like official dates for the early case conference and the beginning parts of discovery, as well as all of the rules they want them to file throughout the court, at least before all the rules that are going to be decided upon in the early case conference. But yeah, I'll get back to it. So yeah, right here. So they need the names, addresses, and telephone numbers of all trial counsel, so all the lawyers and attorneys. Dates on which trial counsel may have conflicts or other complications. So if they have like a vacation scheduled or whatever scheduled, they have to have that in by July 26th. If on the due date of report, all defendants or respondents have not been served, counsel and plaintiffs shall advise the court when service will be effected. So, like witnesses have to be called, etc., and they have to be served. Like, hey, you're officially a witness in this case, right? And if they don't have that in, they have to have a. If it's not in already by July 26th, they have to have it in, like the estimated time when they're going to be served on paper. And then a reason for why it wasn't made earlier, and shall provide a proposed schedule for the required FRCP 26 conference. So yeah. And then whether any party wishes to have scheduling conference in advance of the court's entry, of a scheduling order in the case. So if they want to schedule a conference, so basically say they want to have a hearing on adding new lawyers to, say Iron Mace wants to add new lawyers and they know they're going to be adding them around August, they could go, hey, we want to schedule a hearing for a motion for new lawyers um, on August 28th, right? Um, and they'll have that in by July 26th. Otherwise, they're gonna have to file for another motion later and do all this other shit. It's gonna take more steps. So, and the judge will have the ability to deny it. So, Rule 20 is list the dates that each day every non-governmental corporate party filed its disclosure statement pursuant to FRCP 7-R71 and Local Civil Rule 7.1. Is there anything else here? No. There's a lot of local rules. A certification that all counsel and any pro se parties have reviewed Judge Lynn Chambers' procedures and the local rule, general orders, and applicable electronic filing procedures. So they have to sign a piece of paper saying that, yes, we've read all of her Judge Lynn's rules, her private rules for her court. A certification that all counsel and any pro se parties have reviewed and complied with Judge Lynn's standing order regarding USC Canon 3. So she was involved in a ruling. I'm not entirely sure what the ruling was, but she was involved in a ruling, and if any of the lawyers in the trial were involved in that ruling or acted as witnesses or juries for that ruling, they're not allowed to participate in this case because it could bias their opinion against Judge Lynn. So there's a canon order. So standing order in Canon 3 of the Code of Conduct of the United States Judges. So she made some kind of ruling against X, Y, or Z that pertains to this case, and any judge or any party, witness, or lawyer, or anybody, any counsel can't have been part of that case. If they are, they have to be removed. And I'll go over that order soon, after this one. If the parties are unable to, I don't know what the case was. That'd be very interesting to see what that case would be. So yeah, I'm still expecting early access sometime between the 20th and so now my window is sometime between the 20th and like 27th is when we should know whether we're going to get EA or not. For Nolan. Also, thanks, Day Day. The beard isn't going anywhere. My girlfriend would murder me. Yeah, I would be dead. She loves the old salt and pepper. I'm getting old, man. But yeah, so I have no idea what this ruling was. But yeah, if any of the counsel were part of it, they have to excuse themselves from the court. If the parties are unable to agree on any part of the report, they must answer in separate paragraphs. No separate report are to be filed. If the parties wish to have a status conference with the court anytime during the pendency of this action, they should notify CADA peers, courtroom deputy at CADA, whatever her email address is. Don't email these people, by the way. Do not email these people. They have enough shit to do. Any request for relief must be separately filed as a stipulated motion. Where feasible or disputed motion, according to Local Civil Rule 16-A. And then plaintiff's responsibilities. So this is basically the end of it. So plaintiff's responsibilities, this order is issued at the outset of the case, and a copy is sent by the clerk to counsel for plaintiff or plaintiff if pro se, and any defendants who have appeared, plaintiff's counsel or plaintiff if pro se, is directed to serve copies of this order on all parties who appear in this order is filed. Such service shall be accomplished within 10 days after each appearance. So that means that they have to respond to any motions filed within 10 days of the motion's appearance. Or orders. Motions, orders, anything that they file on the 26th. They have to respond within 10 days. Plaintiff's counsel or plaintiff pro se will be responsible for starting the communications needed to comply with this order. And I mean, I think that includes like this. This is this an order? Yeah. So this order has to be. They have to sign off on this order within 10 days as well, because all that gives them a timeline for all orders, including this one, that they have to respond within 10 days. Early settlement consideration and notification. So this is important. When civil cases are settled early, before becoming costly and time-consuming, all parties in the court benefit. The Federal Bar Association Alternative Dispute Resolution Task Force report this district has stated the major ADR related problems is not the percentage of civil cases that ultimately settle, since the statistics demonstrate that approximately 95% of all cases are resolved without trial. So 95% of cases are all either settled or dismissed before trial. And settlements actually count as dismissal. It's a certain type of dismissal. So, however, the timing of settlement is a major concern. Frequently, under our existing ADR system, case resolution occurs far too late after the parties have completed discovery and incurred substantial expenditure of fees and costs. So what this is basically saying is, like, if you guys want to settle, please settle early, because it saves you money, it saves the court money, it saves everybody time, etc., etc. Most people wait until after discovery, because then they can kind of have the battle of evidence, right? And the battle of injunctions. Because if Iron Mace wins the injunction and has overwhelming evidence that they'll win, Nexon might be willing to settle for less, for just paying their court fees, right? And that would be, then they leave each other alone. They might settle for nothing, you know. So if it looks like overwhelmingly in Iron Mace's favor, they might settle for nothing. If it looks overwhelmingly in Nexon's favor, Nexon might ask for everything, you know. It drastically affects the settlement agreement. But the courts are getting sick of that type of behavior, so now they're adding these clauses in the beginning of this, obviously. The courts can't really do anything, at least to the best of my knowledge, but the district has adopted resolution approving the task force's recommendation that the court-connected ADR services be provided as early, effectively, and economically as possible in every suitable case. So what this means is that they're going to have somebody from the ADR system, the case occurrence, or basically the settlement services people from the court, are going to contact them and try to get a settlement before the 26th even happens. And they're going to these ADR people are going to try to pressure them into settling. And the steps required by this order are meant to help achieve that goal while preserving the rights of all parties. If settlement is achieved, counsel shall immediately notify Kata Peter, courtroom deputy, with her blah blah blah, with her email. Parties are responsible for complying with the terms of this order. The court may impose sanctions on any party who fails to comply fully with this order. Dated June 20th of June 2023. Tana Lynn, U.S. State's District Judge. So that's this one. This is the longest one. The next one's pretty quick. Yeah, I'll go to the comments. What up, Tough RPG? I'm just going over these case documents before recording a video. So these documents dropped today. Brick. Hello from Oregon there, VK. How's Brazil going? So the ADR is, let me look it up, because I don't want to mislead you. I am fairly certain that this is like the people who help, like, the defendant and plaintiff settle. Yeah, alternative dispute resolution is the ADR. Refers to the different ways people can resolve disputes without a trial. Common ADR process includes mediation, arbitration, neutral evaluation, These processes are generally confidential, less formal, and less stressful than traditional court proceedings. So the ADR services, they also have people that advise the plaintiff and defendant on this stuff. Um, so alternative dispute resolution services. So it's people and courtrooms where the plaintiff and defendant can go in and talk to each other and say, hey, what are you willing to settle for? What are you willing to settle for? And then these people and services will step in and say, hey, that's kind of unreasonable, or, you're being unreasonable. And they'll kind of mediate between all the parties involved and help reach a settlement as early as possible. Pirate, welcome. So early access, in my opinion, is probably, or we will know more about early access probably on or before sometime between July 20th and July 28th. Because this document has the date for early case conference, which is July 26, 2023. On or before July 26, 2023. And then they have their initial joint status report for discovery on 8/23/23. So discovery is going to start directly after this. Then they have to file their initial disclosure with all of their information, and then they have to, on the 23rd, they're gonna go over all of the information that's been gathered up to that point, and then they're gonna have an end of discovery date on the 26th. So we're getting all the dates. So this is actually a huge file, at least for me, because then I could start planning out when the trial, like what the rest of the timeline is. So this is a huge document for me. It gives us a specific on or before date for the 26th for the early case conference, which is when all of this stuff is going to be decided. Okay, Brick, how's England treating you? How's the weather over there right now? But yeah, Phantom Banshee, I hope, if you're still watching, I hope that answered your question as well. We'll know pretty definitively about early access at some point between July 20th to July 27th. Like that week. All pouring in the start soon. Yeah, my friend Jack lives out in England. Good dude. He works or he worked. I don't know if he still works there. For a company called Coat Think. Good dude, really good dude. Nope. Yeah, we're on schedule. The 26th. I thought it was going to happen around the 19th, so I was about a week off. But I was close. It seems like they gave them a 30-day extension from the date they requested it, not the day they were served. So yeah, I was about a week off. But yeah, let's get into another document. So we read the minutes with the new judge. Do you guys want to read the rules, Judge Lynn's rules, or do you want to just get into the code of conduct? I'll let you guys decide. The code of conduct is the basically saying that if they were part of a previous court case, they can't be a part of this one. I'll do code of conduct. Let's zoom in here. Let's do 125. So this is the standing order that was mentioned in the previous one. Um, Standing order regarding 28 United States Code, Section 455, and Canon 3 of the Code of Conduct United States Judges. So the court issues a standing order for purposes of compliance with 28 U.S.C. Section 455 and Canon Code of the United States Conduct, United States Judges, 28 U.S.C. Section 544B and Canon both require disqualification of a judge where a lawyer with whom the judge previously practiced law served during such association as. Oh, okay, cool. So it says what the ruling was here. A lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter or has been a material witness. Okay, cool. So the judges can't have worked together or been involved in cases against each other. The judge or the lawyers. So if there's if all right, yeah, can't have worked together, can't have been like if one lawyer was being sued, the lawyer suing them can't be involved in the case because it would form biases, right? So so this is basically like an anti-bias thing. Out of abundance of caution, the court directs the parties to notify if any lawyer at Keller Rohrbach LLP, including lawyers who subsequently depart the firm, served as a lawyer concerning either of the above captioned matter or any materially related matter at any time between August 2004 and November 2021. If no Keller Rohrbach lawyer has served as counsel in this case or any material related matter during the relevant time period, no response to this standing order is required. If notice is required pursuant to the standing order, it shall be submitted to Kata Peter with their email address within 7 days of receipt of this order. However, any defendant in a Kwai Tom, don't know what that is, case may submit its notification within 14 days of the later of 1, its appearance in the case, 2, the dates that operative's complaint is unsealed, or 3, receipt of the standing order. Any receipts required notifications may also be filed with this court under the seal using CMECF system. I think that's the electronic case filing system. The newly filed or sealed cases, plaintiff's counsel or plaintiff, if pro se, is directed to serve copies of the orders or any parties who appear after this order is filled. Such service shall be accomplished within 10 days after each appearance. If this case was assigned to the court after being removed from the state court, the defendants who removed the case must serve this order on all other parties. So this is basically saying that I think it's because both, who was it? Keller Rohrbach is based in Washington, and so is the judge. So if they've had some kind of beef in the history in each other or like work together, like at the same firm, they can't participate in this trial. So I don't know if that's what's going to come from that, but I don't know why this motion would be filed unless something was happening. It might just be an in case. Also, yes, rule number 1 sucks. Nexon sucks. So that's that one. Initial disclosure. So let's go over Honorable Tana Lynn's official rules. So she set the schedule from 9 a.m. to 4 p.m. Ooh, that's a long schedule. With a lunch from 12 to 1. So she's not messing around. So jury selection, court's general voir dire, counsel's proposed general voir dire, I don't even know how to say that. Time allowed for attorney conducted questioning, for clause challenges, preemptory challenges, Oh, cool. So she's giving them 3 challenges per side. So they could challenge basically rulings or petitions or stuff like that. Up to 3 times per side. Um, Number of jurors 25. So she's set the number of jurors to 25 for this case. Maximum. I'm gonna look this up. A preliminary examination of witness or juror by a judge or counsel. Okay, so how do you say that? Voir dire? Cool. So I've had it pretty much right. What up, chicken fries? Do I think that she will be a good judge for this case? It's hard to say because she's very obviously positioned herself to be a political judge. Um, and what I mean by that is she worked as a public defender for a very long time. And that job is the worst job, like, ever. And you don't really go from public to defender to doing what her other jobs were. And I'll get into that um, in the video about this topic. But you don't do the jobs that she did unless you're trying. Hey, ow, kitty. Sorry, my cat wants attention. Unless you're trying to become, like, a district judge or a Supreme Court justice or something like that. She wants to be in politics. She wants to be like a political, like, work for the state judge. But with that aside, everything that she's done has been pretty much like for the little guy, right? You kind of have to be a public defender for as long as she was. You kind of have to want to be there. Otherwise, it'll drive you crazy. Um, and you kind of have to have the fortitude to see some pretty heinous stuff. Um, but she also went on to be like an anti-corporate lawyer. She sued a lot of corporations. She sued the government for overstepping and overreach. Um, she's done a lot of cool stuff that's been like anti-big business, right? And anti-big business, anti-huge government, like anti people messing with the little guy. Um, Seems to be her MO. So I think she'll like her unintentional bias, which everybody has, will probably favor Iron Mace, which is better than nothing. At least in my opinion. That's my complete speculation from the little I know about her. I think I spent like a grand total of like 20 minutes going over her career last night, 20 or 30 minutes. But I do plan on making a video about her and these orders probably tomorrow. I got to work on the evidence video tonight because I already have the script written. But yeah, I think she'll be pretty good for the case. But yeah, let me get caught up on this. Been going for about an hour and 17. Yeah, let me get through this. So they get to select 25 jurors. And they haven't, so they'll decide on a number of jurors on final panel and alternates later. So jury instruction shall be submitted in accordance with Judge Lynn's standing order for trial procedures for all civil cases. In addition to the parties should submit the joint instructions and joint statement of disputed instructions in word format to Lynn orders at WAWD, blah, 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 her email. Um, and they'll have preliminary instructions, a verdict form, neutral statement of case. So this is all the stuff they have to submit to her email. Um, exhibits, deposition designation, juror note taking before or after opening statements. All the notes from the jurors. Questions form juror during trial. Avoid sidebars. Okay, so she doesn't want sidebars going on in her trial. So, what's a good explanation? Okay, so yeah, here's a pretty easy. So the sidebar, as a place. Ow, kitty. Yeah, I know you want attention. She is very needy. Her name is Bird because she hunts birds. It's actually from a book called The Wandering Inn. There's one of my favorite characters is named Bird in that book. Um, but yeah, her name is Bird because she hunts birds. A bird. Um, but she scratches me when she wants attention. It's a habit that needs to break. Um, but yeah, so judges, so like if you see sidebar, it's when they call the lawyers and attorneys up to that little area right by the judge. That's the sidebar. Um, that's the easiest way to say it. Ow. Rule number 2: pet keep meower. That's her rule. Anytime I talk about judges or dismissal or uh, she really doesn't like Nexon. So all of these orders indicate if she's going to dismiss the case, it will happen in the early. It will most likely happen in the early case conference. Where are you going, cat? Okay, hold on 1 second. Come here. Come here, bird. Yeah, good girl. Okay, you want back up or do you want down? You just want attention? Yeah, come here. Come on. Yeah, so the dismissal will happen in the early case conference most likely. So that'll be like July 26th. And then what technology she's allowing in the court. She wants opening statements emailed to her. So schedule audiovisual equipment training and testing if needed. Um, she wants all the witnesses, defendants, all that stuff. She wants that emailed to her. Special witnesses needs issues. Out of town witnesses with disabilities. Witnesses need interpreters, which is going to be everybody. Um, counsel to inform each other of the next day's witness. Counsel to provide courtroom deputy with a list of exhibits to be used with each witness. Stipulations of the parties. Yeah, I mean, this is about it. So this is all pretty standard stuff. There's nothing really out of the ordinary here, except it's kind of interesting to note that she doesn't like sidebars. So she doesn't want the lawyers to be coming up to her and being like, telling her confident. You have sidebars if you don't want the jury to hear something, right? If it's supposed to be confidential between the judge and the lawyers or the witness or whoever they're bringing up to the sidebar. Um, but yeah, I mean that's the biggest news. And then there's going to be 25 juries and then 3 preemptory challenges. This is all pretty standard. Nothing real weird. And then she holds pretty average court hours, 9 to 4 with one lunch, and then there's usually like an hour either before or after. So she's probably working 8 to 5 with the lunch. and then her actual court hours are 9 to 4. But yeah, I mean that's pretty much it for these documents, at least as far as I know. Anybody have any questions or um, concerns or anything? Oh snap! We got up to 36 people watching. That's huge. That's huge for me. I think that this is the most watched stream I've ever had on YouTube. Um, but what else was there? Let me look at my. Oh, this is about the standing order. Okay. Sort of set forth procedures that govern all civil cases against are assigned to this court. This order applies to all counsel. So this is local standing order for all civil cases. And that there is an inconsistency between the order and the local rule of the federal rules of procedure. In terms of this order control, failure to comply with the procedures set forth in the order may result in sanctions. In terms of this order shall have the force and efforts in order. It's all pretty standard. Case was previously assigned to different district judge. Those procedures replace those that previously controlled, but only as to filings and hearings from the date reassignment. So anything on or after that date is now Lynn is in charge. Anything that the other judge chose, which was basically nothing, stands, but anything on the day or after the day that Lynn is involved, she's the one who makes the decisions. Party shall review Judge Lynn's procedures. That's what we just looked. Providing any hearings or trial potential updates or modifications of this order, as well as additional information regarding general practices. So this is the local rules for the court. What up, BC? Do you think a jury is better or worse for IRM if it gets that far? It's going to take longer. So in that effect, it's worse. Yeah, in that effect, it's worse because it's more time consuming and more up to the will of the people, basically. But I do think that jury trials are a little bit more fair and equitable because it's the opinion of up to 25 people that you're trying to sway, right? Instead of just one person who might have some kind of internal bias for or against you. So in the party in the in the case of fairness, I would say it's, in my opinion, better for the jury trial. It's better for IM, but it's going to take them longer to, because juries very rarely get it their ruling by the first try, right? They're not going to get it on the first day of trial. Whereas a judge could have had this over with like in a day if it was just a judge trial. But yeah, it's going to take longer, but it should be more fair. Um, and as a whole, I think the people of Washington are more like anti-corporate than they are uh, for big corporation. So I think the people that are selected are probably going to go in there with internal biases against corporations, unless they're all old people, because for some reason old people love corporations. Um, yeah, so if it's a bunch of like 60-year-olds, then it's probably bad. But if it's a diverse jury selection, it'll be a good thing. The structure and typeface, nobody cares. Citations to unpublished legal authority when filing a motion or brief that cites to a ruling from a court outside the jurisdiction that is not readily available on Lexis or Westlaw. Transcripts containing bench rulings. A copy of the ruling must be provided for attachment in the motion. Interesting, but not a banger. Um, refer to the table of contents. Cool. I'm just looking for anything kind of like interesting in the local rules. So we've read through Lynn's rules, and these are the local Washington rules. Courtesy copies, noting dates. So yeah, okay. Here's the court follows LCR 7, so I gotta look that up. So that's a local court ruling 7 to see how they actually count their court days. LCR 7. Let me see how they count their court days. Form and scheduling of motions. Okay. So they use court calendar. Okay, so all motions shall include in the caption immediately below the title of the motion. The date of the motion is to be noted for consideration upon the court's motion calendar. Okay, cool. So if all motions follow like a motion calendar, there's a court calendar of when the clerk is in schedule and all that stuff. So they do file the court calendar for all motion days. The noting date is the day by which all briefing is completed and the matter is ready for the court's consideration. Although the court may not issue a ruling on that day, the form this notion shall be as follows. Note on motion calendar, obligations of opponent, reply brief, oral argument, decisions, motions. Okay, cool. Got it. Now I know how their court calendar works. How how's the games going? Good. Um, games is accurate. I have a few. Um, do you guys want to see it? Do you guys want to see for the first time live on camera me run through my game? I mean, I've done with all of these documents are pretty standard. There's nothing. There's not going to be anything exciting in these local rules. I'll look through them and then kind of give some explanation if anybody wants it. But there's not going to be any like breaking news pertaining to Dark and Darker in these. This is just kind of how the local, opportunities for settlement. We just went over that. They're going to be close to the federal rules, just with minor differences. And we already went over the federal rules. They're listed out in that document, the before document. Oh, this is exciting though for me. Otherwise, unless otherwise specified, hearings are in person in Washington. Counsel from outside of King County may appear by telephone or video at status conferences and hearings on non-dispositive motions, but they must request and make arrangements with the courtroom deputy ahead of time. So if this goes to full trial, it's in person, unless there's like some kind of exception. That is huge. So everybody that's in Korea is going to have to come over to the United States District of Washington. So to come to Seattle, that's such a pain in the ass. It's going to cost $1 bajillion. Oh gosh, that sucks. That sucks really bad for Iron Mace. Um, yeah, I can't have cell phones. They have to all be in airplane mode or turned off. Other than that, yeah, there's not really anything super. The only cool thing was them having to be there. That sucks, but it's pretty standard. Let me pull up my game. because I do mention this in the video that I'm releasing tonight. So I'll show you exactly what I'm talking about. Do 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 do. Let me go into the level. Don't steal my game, guys. Um, so yeah, here it is. But so what? Here's what I was talking about: the torches. See see this torch? Um, Nexon claims that it took them 3 months to get the lighting on that torch right, and this is basically just stock. Like if I just come here, double click on this, I haven't changed any of the configure defaults. Like this is all normal. I haven't changed anything for how the torch functions or looks or the color or anything. So this is just out of the box. So if I go here and edit the blueprint, torch fire, I haven't. It's the same exact thing. So they're just straight up lying. I haven't changed any of the smoke elements. I haven't changed any of the lighting elements. I haven't changed anything. So, and I use this kind of as evidence because these blueprints are all um like here's the viewport, and I could delete this little background and just have that part, like the little brick. Um, but yeah, these torches they claim that it took them 6 months or whatever to make this torch, and it's just a blatant lie. Because this is the exact. It's the exact same color scheme that I have, and like if I turn off the so what do I do? Let me post processing. That's obvious. It's going to make it brighter, but the there we go. I have exponential height fog, so it cuts off the distance. Um, it starts getting foggy after a while. I'm going to change the how that looks, but if I take it off, it looks even more like how they have that picture, right? And here's like live in game. Don't mind all the text, but yeah, live in game. It's basically standard. I need to move all this stuff. This level is not finalized, but um, and the camera needs to be adjusted a little bit. None of this stuff is final, but yeah, this is one of the levels. Here's one room. This is like a big ass room. Secret pro tip: you can go in the water. I'm gonna add swimming. You can go through these bars. Boop. Um, into another big ass room. So yeah, you'll have swimming. And there's going to be lots of secret rooms. I might cut down the space on this a lot. Um, where's the prison? I think it's right in here. No. Where is the prison? This way, this way. Here we go. Boop. Little prison set. Prison. But yeah, this is basically it. Um, yeah, I need two screens. I need two screens. Hey, streamer, look at chat. You can't see the light? Oh, the screen is black. Oh, shit. Sorry. I've been going off here for like 5 minutes. Is it still black? What about now? Is that better? There we go. Can you see it? Yeah, I was talking about like here's the campfire. I have the same campfire that they use, except it's not surrounded by rocks. I took the rocks away and put it inside of a little can't remember what those things are called. Like a little fire pit. Here's the like they're claiming that it and Nexon is claiming that it took 6 months to make these fire pits and torches. Like that's just one piece of evidence that I found. I use this like the same exact ones. I have these bricks attached to them. You can modify all this stuff. I took the bricks. I haven't added the bricks for the campfire, but yeah, this is like completely movable. Like, and it's stock. You know. Ta-da! Here's a little campfire thing. Here's the fire itself. Like it's not very. Nexon is just straight up lying or dumb. I'm showing all the trade secrets. I'm showing you guys Nexon's trade secrets. But yeah, here, let me go back to the first room. Yeah, they're Nexon is either straight up lying or dumb. I use it like you ain't go fool me, Nexon. I use the same shit. Like they're just dumb. Um, but yeah, they claim that these lights took 6 months to make. No, you bought them from an asset store and you didn't even modify them. Um, they claim that like bricks like this and the floor. No, these are all from asset packs. You want to see the asset pack? Here we go. Um, let's see. Where is it? Medieval dungeon blueprints. Here's the stock blueprint, unmodified, for this torch. Here we go. Look at that. 6 months of work, guys. Straight from the asset pack. 6 months of work. I managed to do it in literally 30 seconds. Let me get another torch out from Dungeon Ruins. Where is it? Small torch fire. Let's see. Oh, there we go. Look at that, guys. 6 months worth of work. Like, they're Do I have players in? No, I don't have any. So I have locomotion and stuff set up. So here, like I'll push play, but right now I don't have the characters in, and I don't have the interaction stuff. I have it built, but I don't have the interaction to open the doors or anything. Oh, also look at these doors that are similar. That was 6 months worth of work. See how they don't match the door frame though? I'm gonna have to stretch them out. They claim that they claim that these doors. I built different handles, but and I picked a slightly different door. Like I built these handles from from other stuff that's in here. Um, but yeah, they next one's dumb. They no, inventory is kind of functional. Um, chat system's kind of functional. The quest system's kind of functional. There's all kinds of stuff that's kind of functional. Oh, I need to delete this. Deleted. Also, I don't think that's supposed to be there. But yeah, guys, insider trade secrets. If you buy asset packs, you can apparently claim that it takes you 6 months to set up the torch lighting mechanics, when it really only takes you like 2 seconds. This is all out of the box. Like I haven't adjusted any of the lighting on this yet. I will. I'm probably going to make it a tiny bit more orange instead of yellow, but no, it didn't take 6 months. And this is like almost exactly what P3's lighting scheme looks like. And if I take away the post processing, all it does is make it brighter. So if I go into lighting, post processing, obviously it's going to get lighting. It's going to get brighter. But I have post processing to limit the light threshold, and I could increase the like depth of field and all that stuff through it too. Do I make it play like Dark and Darker? Not really. Yeah, the article I was reviewing was dropped. There's one that was dropped like yesterday, and one that was dropped, or a few that were dropped today. Yeah, you can walk around and stuff. Walk around and jump. It's so this game's third person. My game's third person. The combat's going to be more like action combat. The HUD's not set in stone yet, obviously. But yeah, there's going to be a stamina component. It's going to be like more like New World combat, action combat, third person. And it's going to be kind of like an MMORPG where you have a hub. Oh, that shouldn't be doing that. Found a bug. Like MMORPG, but with dungeon crawler aspects of it. But it will be either partial loot or full loot. PvP dungeon crawling, and then there's going to be entrances and exits. So like if you come up here, like through this door, here's a static entrance. So let's see if my inventory system works. Yeah, there we go. Ta-da! But yeah, so there's a static entrance up here. This is kind of my test room. So people are going to come in up here. And then there's going to be... So a static entrance up here. There's another static entrance on the other side of the map. And then there's a second floor to the dungeon below. Let's turn on unlit. Wait a second. There we go. I went too far down. So there's a second floor down here there's going to be two entrances on the bottom floor. Two entrances, like this is not finished being built yet. This is all just gray blocked out. But let's go up and figure out where the hell we are. That's my shadow box. Cool. So yeah, so then this goes down. This is just a walkway down. This is oversized. I gotta make it smaller. And obviously, like, this is just gray block stuff. But yeah, there's like a big sewer pit right here. The swimming's not on, but there's going to be a monster in this pit, big ass monster in this pit. Some secret passageways back here, all kinds of stuff. But yeah, it's more of like a, sorry, my nose is itchy as fuck. Um, shit. There's all kinds of cool stuff. But yeah, it's a third person um RPG that it's like a dungeon crawler RPG basically with third person action combat. But yeah, the main point of me showing this wasn't to show the game off. It was to show that this stuff it doesn't take 6 months. So they're grossly misrepresenting how much time they're spending on elements that are basically stock, right? They're pulling this stuff out of asset packs. Like, this is almost exactly to what the P3 asset looks like. Um, and they're just claiming it as their own and claiming that it took them 6 months to do it. And it's just grossly misrepresenting their process. So, but yeah, no juicy bits yet. It's basically just a waiting. Yeah. So do you have a timeline? Player physics in yet? Like, be able to walk around? Yeah, I just showed it. I'm gonna change the locomotion and stuff, but um, yeah, I don't want to sit here and advertise on a Dark and Darker stream. So I'm gonna shut this off and switch it back to window cap Acrobat. Yeah, if you guys have any questions about it, just let me know. It's gonna take a while. I'm just solo dev. Um, but yeah, I mean, that's so to do like a quick recap before I start, because I do have to record that other video. I want to get it live sometime before 12 p.m. tonight, so I got to record it. Um, but yeah, so I use my game kind of as like evidence that that Nexon is bullshitting. Um, and they 100% are. So like if I look at my script for the video, so here's some like behind the scenes info from the video. Let me look it up. Let me get it. File download. Here we go. So this is like the entire reason why I was showing you the. Here we go. So here's the script. It's what should be on screen now. It's 14 pages. I have it up on my Patreon in full. Um, but a lot of it's evidence. So like, they're claiming that these torches took them 6 months. This one also has up in the top right, and the top left. It shows like battle royale stuff if you look really closely. But they're claiming that they misrepresent a lot of information in the DMCA. So in the DMCA alone, they misrepresent how much time this torch took. They misrepresent the classes. Tanker and fighter weren't added, or tanker and or sorry, Rogue and Fighter as classes weren't added until just before the DMCA went out, or maybe even after. And their class system was also misrepresented in the DMCA, um, and in the complaint. And the complaint has a bunch of stuff. Like I have evidence for the um, Rogue, Fighter, Wizard, Thief, Tanker. Like the Rogue and Fighter were added later than everything else. Um, so both of these images are actually from P3, are actually from Dark and Darker. This one's from a playtest in playtest 4. So this is a screen cap from playtest 4. And then this one is a screen cap from the Wikipedia. Here's all of the... We know this is playtest 4 because it's the skeleton icon, meaning that this player had the skeleton skin on, which was only available during playtest 4, if I remember correctly. More evidence is like this is directly pulled from all of the. So this is pulled from Dark and Darker. This is directly pulled from the asset for this mimic. This is directly pulled. That's on this. So this is a screen cap of Unreal Marketplace, essentially. So is this. So is this. None of this stuff was actually in the game. This is pulled directly from the Unreal Marketplace. I went over this showing my game. I literally just showed you a modified version of this exact same door. Mine has different handles and different strapping, but the claim, for example, Nexon selected a door below left for P3 from the Unreal Engine Marketplace, but customized it by making it wider than the stock door. Defendants selected the exact same door as Nexon for Dark and Darker on information and belief, widened it in the same manner. And as I showed in my game, you have to widen it, otherwise it doesn't fit properly. So this is just a gross misrepresentation of why it was widened, and they're trying to use this as evidence that they're using the same. It's the same asset, yes, same asset. Mine has different handles. I modified mine more heavily, but I haven't widened mine yet. You have to widen them to fit, otherwise there's gaps in the side and in the top. It's widened and lengthened. So there's just kind of misrepresenting a lot of their statements here. So identical sitting position, they use the same sitting asset pack. I have that same asset pack. I haven't implemented it yet, but there's the same locomotion asset pack that includes the sitting animation, and both games use it. So is my game's going to use it too. Unique yellow-orange lighting, in addition to taking months of trial and error to perfect. Choosing this lighting, this is all in the complaint. Choosing this lighting required more than the minimum level of creativity to be protective as authorship. Dark and Darker chooses precisely the same lighting. No, it does not. All of this lighting is, you just pull it straight out of the asset pack, as I just showed live on camera. Yeah, they're just straight up lying through their teeth. I put a screenshot of my game in. So this is a representation of how it was a battle royale instead of a extraction game. Last Man Standing Team 2. Then they claim something about the bubbles being the same, even though one's blue, one's red. They're shaped differently, and different. And this was just a universal buff bubble, according to Nexon, and these have specific properties. And then some evidence. So this is kind of going over what the video is going to say, but this potion is, if you look at it, see that pink potion? I wonder where that's from. Real Liquid X. So their whole claim is that in both games there are potions that provide restorative powers. In P3, the potion flask lights up and is fastened to the character's waist. While restorative potions are a common feature in dungeon crawler games, the light up feature and the placement of the flask are unique to P3. Moreover, returning to the theme of light and darkness in P3, Nexon's developers consciously added the light up feature, which illuminates the surrounding settings. Defendants copied the unique potion flask that lights up and the placement of the flask at the character's waist in Dark and Darker. Not true, again, because if you look up the real liquid potions, they come glowing. That's how they That's how that's how they operate. When you, I'll just click on the link and show you guys. So here is the Unreal Marketplace window. Where is it? Why isn't it working? Weird. Here we go. So I'll move the. Oh, sorry. I don't know why this is all messed up. Boom. But yeah, if you look at the real Liquid X on the Unreal Marketplace, it comes glowing, even in the game settings. You can adjust the glowing properties there. So they're just straight up lying. If you look at the video, introduction video. Sorry, I'll mute these. Ta-da! But yeah, you could change the liquid settings inside the potion. But they start out glowing. And they actually start out pink. So yeah, it's pretty ridiculous. Let me go back to the. There we go. Yeah, it's so my point is the point is basically to prove a pattern. Um, I go over a lot of stuff in the video, and one of the opinions is like I don't think like nobody's going to be accused of perjury. You know, I don't think like nobody's going to go to jail for this. But what they're if you have like a series of events where they're just grossly misrepresenting facts and they're just like blatantly lying. Sorry. If they're just blatantly lying, then a lot of this evidence can be thrown out, right? So, and if you start throwing out enough evidence, their case starts to lose weight. And the more of these things that do end up getting thrown out or questioned by the judge, or even have less merit, I honestly think Iron Mace has a very good chance of winning this because Nexon is just straight up lying through their teeth. Like, and it's easily proven. It's not even like it. I'm an idiot, and I was able to find all this stuff. And luckily for me, I just happen to have used like some of the same asset packs. So it's like I found this stuff super easily. Iron Mace's team 100% has the same information, if not more. I need to get more water. Yeah, it's just nutty. I'm not an idiot. I try not to be, but yeah, it's I'm not the smartest person in the room. I'll say it that way. I just know how to do research. So yeah, they just make a. Our Nexon is just making a shit ton of false claims. But so to answer not too shoddy your question is we learned the dates for the early case convention, our conference, early case conference, which is going to be July 26th. The initial reporting for discovery is going to happen on August 23rd. Any kind of dismissal or the injunction will happen on July 26th. That's the important stuff. We went over the rules for the court, um, the local, federal, and personal rules for the judge. We learned who the new judge is. Um, and what else did we learn? We learned that during the actual trial itself, any witnesses and testimony, unless there's some kind of emergency, they have to show up in person. So all the people are going to have to show up in person through from Korea and go to Washington. But which means that if this does go to trial, I'll probably end up going to Washington, to Seattle, and I'll be there in the court. And I'm gonna try to get SDF and Terry to shake my hand. And if Grayson's there, I'm gonna bug him. I'm gonna tell him to make me a troubadour. Um, but yeah, there's a new judge. There's a lot of new information. We got a pretty accurate timeline that I can extrapolate that information into a much longer timeline to see when this could go to trial. And the latest date this can go to trial, if it makes it that far, would be no more than 12 months from the day it was started. But yeah, I save all my live VODs, so this will all be recorded. Um, so if you want to watch it and kind of skip through, you'll find out. I also went over some of the evidence that I'm going to have in the video. I'm going to record in probably like 20 minutes. But yeah, this is 14 pages, 12 out of 14, 14 pages of this stuff. There's a lot of it, but yeah, this script is available on the Patreon if you guys want to go check it out. Um, but I think I'm gonna grab a quick bite to eat and then get right to making that evidence video. I want to get it over. I want to get it done with. It's going to be a little bit longer of a video because there's just so much evidence, and this isn't even all of it. This is just from the DMCA and the original complaint. So, but yeah, I hope. Thanks for watching. Thanks for sticking around. Huge thanks to Mike for the $10. That's amazing for the super. You guys are freaking awesome. I can't believe it. Like this is crazy. Um, but yeah, I won't be filming the vid live. I'm gonna record it and then edit it. Um, I mean, I guess I could, but I need to eat food and stuff, and I need more water. I'm probably gonna bring my AC in here, so I need to get set up. If I do record it live, then I will post in my Discord. So there should be a link, but what am I gonna do besides Dad? So I've been contemplating getting Diablo 4. Well, there's a lot of my friends are trying to get me into Diablo 4. A lot of my friends. I used to run a company on New World. We owned Windsward and Everfall, and we owned a bunch of stuff. If you know New World, they are trying to get me back. I was the leader of the company, and they're trying to get me back to do some more stuff. Um, but when Dark and Darker comes back, I plan on streaming a lot of Dark and Darker content. Um, Gameplay. I'm gonna do build. I usually do build guides. I'm like a lot of theorycraft. I do a lot of theorycraft stuff for builds. Like if you look at my New World content, it was mostly build guides, how to run wars, spreadsheet stuff. Um, I like to do a lot of the math and stuff. Um, but they're trying to get me to go back to New World. I'm not sure if I will. Um, I might. They're pretty convincing. And if I don't have to do a lot, one of the reasons why I quit New World is because there was a lot of work running a company and there wasn't a lot of reward. I was on like 10 hours a day almost. It was like a full-time job almost, and I didn't get paid for it. And um, it just made it so I couldn't play how I wanted to play, which sucks. It was not a lot of fun. So, but if I can make some good content and do what I like to do, then I might go back, and at least until New World or until Dark and Darker comes out. Raptor, Raptor, what have you been doing? Raptor knows he was there. Psycho Raptor was with me in the New World days. This guy's a killer. One of the better duelists on our server. ETA on early access after seeing all this? My guesstimate is, my estimation is between July 20th and July 27th is we'll know more information about EA. Because that's when the early case conference in the U.S. is July 26th, and the injunction the pre-trial hearing for the injunction in Korea is on July 16th, I believe, or July 20th, 21st. I can't remember. I think it might be the 21st. I'll have to look up the date, but sometime around the 21st. So like basically like the 21st to the 27th is my estimation. I think it might be July 19th is when the date for the pre-trial hearing was. So yeah, July 20th through the 27th or 27th would be my timeline. Raptor, are you gonna play Dark and Darker? Because if so, we gotta murder some fools. Yeah, that'd be rad, Shoddy. That'd be a good birthday gift. If we get the injunction, if Iron Mace wins the injunction fight in Korea, I think EA comes out like the next day, basically. So like the 20th or 21st. Yeah, I would love to have like some kind of guild or clan system in Dark and Darker as well. Um, but yeah, guys, thanks for watching. I think I'm gonna hop off. I've been streaming for about 2 hours. If I come back on, I'll let people know in the Discord. But yeah, I want to get that video filmed before 12 and up posted probably before 12. At least scheduled. But yeah, guys, thanks for watching. I'm gonna head out. Peace. Let's do it, Phantom. Join up. Get a group of us going. Thanks, guys.